I give the floor to Mr. Heijmans.
Dear Madam President, dear honourable judges of the court, my name is Johan Heijmans, and together with my colleague Johan van der Lanotte, I will plead today before your court in order to defend the interests of Mr. Yüksel Yalçınkayan. I will concentrate on the questions of your court relating to the bylog evidence affecting Articles 6 and 8 of the Convention, while my colleague will deal with the limitations imposed on applicants' freedom of association and on the lack of independence of the Turkish courts in the present case, affecting Articles 6, 7 and 11 of the Convention. Before I start, I want to emphasize that this case is of the utmost importance, not only for applicants, but also for the thousands of Turkish citizens who are also suffering from similar grave human rights violations and who are also confronted with arbitrary trials. Your court has often stated that justice must not only be done, but also seen to be done. But perhaps it is even more important that when no justice is done, that this is also seen. And that is exactly what is the case in the present application. Before I delve deeper into the contents of the case, I want to briefly address a procedural point that was raised by the Turkish government. Notably that not all violations which are addressed in the questions of your court have been raised by applicants in the domestic proceedings. That is simply incorrect, as is demonstrated by our Annex 1 to our summary. And that document clearly shows that all the points which are raised in the present application have been, at least in substance, presented to the domestic courts, or often explicitly by referring to the articles of the conventions before, notably, the Turkish Court of Cassation and the Constitutional Court. If there are any additional questions or ambiguities on this point, I will address them in rebuttals. Because today I want to focus on the merits of the case, since it concerns, as I already said, very grave human rights violations, and that is particularly true with regards to the use of the bylog data. In order to briefly remind you of the pertinent context, bylog is an encrypted application that could be downloaded by anyone all over the world through the Google Play and the Apple stores. Worldwide, 600,000 people downloaded this application through one of these stores. Still, suddenly, in 2016, the Turkish government suddenly decided that this application, and I quote, was exclusively used by FETÖ, which they considered to be a terrorist organization. And for that reason, the Turkish National Intelligence Organization, MIT, tried to get a hold of these data as quickly as possible. At this moment, we have no idea at all whether MIT managed to do so, and if so, how they managed to do so. The only thing we know for sure is that the servers of this bylog application, that they were located in Lithuania, and that MIT claims that they have managed to collect the IP addresses and communications held by the bylog users. In order to link these IP addresses then to concrete individuals, they relied on history traffic search records, HTS records, which were held on to by the Turkish Information Technologies and Communication Authority, called BTK. In the present case, applicant has always denied till today that he has ever used the bylog application. The Turkish government claims otherwise and reproaches to applicant that he would have used the bylog application on 6 days in October 2015. And it's that use of the bylog data which eventually resulted as the decisive element to convict applicant to a harsh prison sentence of 6 years and 3 months. Now, as to the specific questions of your court regarding the Articles 6 and 8 of the Convention with regards to the bylog data. There are a lot of questions, but perhaps in order to address them logically, it is best to do so chronologically by addressing the questions from the moment the data were gathered till the moment these data were used to convict the applicant. If you look at the stage before the proceedings against applicant even started, the bylog data, again, if they were gathered, they violate Articles 6 and 8 of the Convention for 2 main reasons. The first reason being that these data they were gathered in violation of the Turkish laws, or in any event, do not have a solid legal basis. As to MIT, we know that they claim that they have gathered these data in May 2016, without having a court order allowing them to do so. The court order only followed 7 months later, in December 2016. In the meantime, these data had already been used to deprive Turkish citizens of their freedom. And this notably happened to an applicant who was put in pretrial detention on the 9th of September 2016, 3 months before the court order. Such actions are totally contrary to Turkish law. And it is clear that from this Turkish law that normally MIT, when they want to take an action, they need to have a court order beforehand, or if there is an emergency, that within 24 hours they need to rectify the situation and obtain such a court order. But that didn't happen in the present case. And Turkey is aware of that problem and therefore tried to fabricate a legal reasoning on an alternative legal basis, more precisely the Article 6, paragraph 1 of the law on MIT. But if one looks at that article, it is very vague, merely containing some definitions and general principles, and therefore can never qualify as a law in accordance with the strict jurisprudence of your court. In other words, such paragraph would allow MIT to do anything they want without any limitations or judicial control. And Turkey itself is aware of this, because in 2005 they supplemented this article with 5 additional paragraphs, notably providing these checks and balances and requiring explicitly that when MIT wanted to intercept communications, they need a court order. But still, MIT did not comply with these provisions, and also the Court of Cassation of Turkey completely ignored them. And the same applies with regards to the records, the HTS records, which were collected by BTK and the telecom operators. Both applicant and the government seem to agree that these records were held on to largely beyond the maximum retention period of 12 months. But the government says that that is not their concern, that this is the responsibility of the telecom operators. First of all, that is completely incorrect. What really happens is that the telecom operators, they gather these data, and when the maximum retention period is approaching, they transfer these data to BTK, which is a government institution, and it is then BTK which holds on to these data beyond the maximum retention period. But even if you would follow the Turkish reasoning, then still such reasoning would be way too easy, because that it would mean that states would just outsource all their illegal activities to private players and never be held accountable. And that would violate Article 5 of the ILC draft articles on state responsibility, but also go against the jurisprudence of your court, notably the Mutu and Pechstein versus Switzerland case. Moreover, holding on to illegally obtained data, which then the government eventually did, is a crime under Turkish law. Articles 135 till 138 of the Turkish Criminal Code. And the Turkish Constitution and the Turkish Code on Criminal Procedure explicitly provide that a criminal conviction can never be based on illegally obtained evidence, which happened in the present case. The second reason why the BILOG data violate Articles 6 and 8 of the Convention is the fact that we have no idea at all as to how they were gathered and how, consequently, their integrity was preserved. As to the way these data were gathered, we have multiple explanations. The judge, in first instance, in the present case, considered that these data were bought of Lithuania, but other documents claim that these data were stolen by MIT officials who went to Lithuania. In any event, however it may have happened, one thing is sure today, is that we have no idea at all as to how these data have ended up, if they have ended up in the hands of MIT, how they have ended up there. And this casts a shadow of unreliability over the data in their entirety. And the same applies with regards to the way they preserve these data. The only thing we know for sure is that these data have been tampered with. In this regard, one can take a look at the report, the expert report of Professor Baha Sen and digital forensics expert Rafet Ongokmen, both appointed by Turkey itself, who confirm that the data have been manipulated on the 26th of October 2016 before there was even a court order. So even if today the government would suddenly come up with these original bylog data, there is still no way to satisfy the chain of custody requirements that your court requires with regards to such data. Then if you look at the proceedings against the applicant itself, we clearly see that his right to a fair trial has been violated. Also for multiple reasons, the first ground being, and that is really crucial, that during the domestic proceedings, the communications that the applicant allegedly had through bylog and the original bylog data were not made available to both the applicant and the judges. The alleged communications that the applicant had through bylog were only made available in this proceeding before your court under Annex 27, and so not before the domestic courts. And the original data set regarding bylog has, in spite of the explicit request of your court, still not been made available to notably the applicants, but also not to your court. And this is really problematic because all those years the prosecutor has had this data, and he refused to disclose them to notably the applicant and the judges. And this is problematic because the only way for the applicant to effectively defend himself was to have access to these two sources of evidence. Because in the case file he was confronted with MIT and BTK and police reports, which were very brief. If one looks at the annexes that are presented by the Turkish government on this point, these reports are only 1 to perhaps 2 pages long. And they are so vague that you cannot really challenge anything. So the applicant was not in the possibility to effectively defend himself against the allegations that were held against him. The second reason that his right to a fair trial was violated is the fact that, in spite of the fact that he 4 times asked in writing, he did not obtain during the proceedings a copy of the bylog data, while normally, under Article 134 of the Turkish Code on Criminal Procedure and Article 17 on the regulation on judicial and preventive searches, an accused automatically gets a copy of these data. He doesn't even have to ask for it. But in the present case, even in spite of your court asking for these data, nobody has received them. The third and final reason is the fact that applicants also asked on multiple occasions to obtain an independent expertise on these digital data, and he has not received this expertise. It is true that before the Regional Court of Appeals, there was an expert appointed, but in reality that was not an expert, because that man kind of made a summary of the case file in a 5 pages long document. He couldn't really make any other reflections because of the fact that he didn't get access either to the alleged bylog communications or the bylog data. And that was also the problem of the expert that applicant eventually assigned himself, Mr. Kilic. That man could not really make any reasonable conclusions either because he had no access to any concrete information. And so he could only conclude that the allegations were vague, that technically speaking they were conflicting, and that technically speaking they were unexplainable, these allegations and reports of the government. And just in order to show you how confusing the situation is, I want to give you one example. So the BTK and MIT reports always stated that the applicant used his bylog application in October 2015, 6 days. But if one looks at Annex 27, the alleged communications through bylog of applicant that are now submitted to your court, it is held against the applicant that he sent one message through bylog, and he did so not in October 2015, but in May 2015. So that means that after all these years, we still have no idea when the applicant would have done something problematic and what exactly is in the data set that the government keeps on holding on. And if you look at all these drastic limitations of applicants' right to a fair trial, it is also clear that they are not counterbalanced by anything. The Kayseri Assize Court took applicant's case in one hearing and ignored his argumentation. The same for the Regional Court of Appeals. They initially asked to join to the case file the alleged bylog communication of the applicant, but when that didn't immediately happen, they went forward and they confirmed applicant's conviction. They ignored his arguments and they solely relied on the alleged expert report, in reality a summary of 5 pages of the case file. And so if you look at all these elements, this case is very different from the Rook versus Germany case of your court, because here applicant has not had any access at all to any of the relevant data or elements in this case, and it are still these bylog data which have been the decisive point to convict him to this harsh prison sentence. Finally, it is important to emphasize that often the courts have stated that this bylog application was exclusively used by veto. But the government knows too that that assumption is not correct. In that regard, I can just refer to the Beyin incident, where 10,000 prosecutions of individuals who downloaded the bylog app were stopped by the prosecutor in Turkey because of the fact that these people were deemed too close to the AKP party. And so there was no prosecution of 10,000 individuals who had bylog on their phones. And furthermore, the fact that bylog is not an irregular means of communication was also confirmed by international institutions such as the United Nations Working Group on Arbitrary Detentions, but also to some extent by the jurisprudence of your court in the Akgun versus Turkey case. And in the light of all these elements, it is clear that manifest violations of Article 6 and 8 have happened with regards to applicants. I thank you, Your Excellencies, and will now pass the floor to my colleague, Johan van der Lanotte.
Thank you.